All right, folks, buckle up. We're diving straight into a wild courtroom saga involving Mr. Latrell, allegedly crawling on the lawn, shouting about his daughter, and a police encounter that escalated fast. Was it a mental health crisis, intoxication gone wrong, or something more? Stick around, because we're breaking down the facts, the legal stakes, and every jaw-dropping twist that could shock you. You won't want to blink. This one's packed with suspense, drama, and legal chaos.
The initial 911 call that came in reported Mr. Latrell engaging in some odd behavior, including crawling around on the grass, making comments about his daughter being kidnapped. And so certainly things that would lead a reasonable person to believe that he was suffering from some mental illness. Now, with that being said, he was also highly intoxicated, and we don't challenge that in any way, shape, or form. He admits to that. He understands that. He's been working on his sobriety since this occurred, so we're not arguing that he wasn't under the influence as well. But the request was really in the nature of getting him some help, more so than it was getting law enforcement involved because of any criminal activity that he engaged in at that time. It did result in a violent encounter with the police. We certainly understand that the court takes those things seriously, so we don't mean to minimize what occurred. There was some body cam footage of it as well.
Now watch closely as the body cam rolls. Here's where the situation pivots from a reported disturbance to a full-on confrontation. Mr. Latrell orders officers off the property, which might seem bold, but legally, that's a huge no-no. Police are trained to respond firmly to unlawful commands, and refusing to comply immediately escalates risk. Notice the tension. He's physically ill, intoxicated, and resisting at the same time. This is exactly the type of case where mental health intersects with criminal law, creating a volatile mix. What would you do in this situation if you were on the scene? Comment below.
And when the body cam starts, you see Mr. Latrell ordering the officers off the property. Officers obviously said it doesn't work that way. When he refused to follow their lawful command, specifically to get on the ground, that's what resulted in the confrontation with the police. He was physically.
Mr. Latrell, you don't have to tell me anything today. If you don't, I don't hold that against you. But you may make any statement to me you wish. Is there anything you want to say, sir?
I just appreciate any considerations, and thank you for your time.
How willing are you to take care of this Indiana outstanding warrant?
I could take care of it as soon as I have this taken care of.
Well, I mean, you've been able to take care of that since 2017.
Yeah,
You failed to appear.
I did run from it. I admit to that. But
if I even consider putting you on probation, the condition is you got to travel to Indiana and physically own up to that warrant. If they put you in jail, they put you in jail.
Okay.
You're willing to do that?
I would be willing to do that.
Mr. Radsbot, any recommendations from people?
Judge, first of all, we agree with the recommendations of the department. And I think even with the recommendation for jail, some period of probation, I think, is important to follow up and make sure he is continuing with his mental health treatment and his medication, and B, remaining sober. Judge, had he been following his medication regimen, we might not even be here today. If he had not compounded that mistake by then consuming alcohol to the point of intoxication.
Here's the turning point. The prosecutor breaks it down. If Mr. Latrell had been following his prescribed medication, none of this might have happened. But add alcohol into the mix, and suddenly 4 officers are at risk. A violent struggle ensues, and the courtroom has to untangle responsibility. It's a classic example of compounded poor decisions and how the law holds people accountable for foreseeable consequences. Let's pause and think. Should the legal system weigh mental health more heavily? Or is accountability still paramount here? This is the kind of debate that keeps attorneys, judges, and audiences divided.
Without taking his medication, we probably wouldn't be here today. But the bottom line is he did both, and as a result, put 4 officers at risk, got into a heck of a tussle with the 4 officers, tried to spit on them. We can't have our officers subject to that, Judge. So some consequences is appropriate. They recommended 9 months. I guess I would leave that up to the court's discretion, but I don't think that's inappropriate. It's about the middle of the guidelines. And insofar as any lingering issues in Indiana, yes, he'll have to take care of it, but I think he should take care of what I believe is his obligation to the law enforcement here by serving some time in jail and with some probation on top of that.
Well, Mr. Latrell, this is, not a complicated charge. Resisting obstructing police is a fairly complicated charge. It's a 2-year felony. The guidelines are 0 to 17 months. We see these types of cases a lot, and they're on a sliding scale of how, any failure to comply with a lawful command of a police officer is resisting obstructing that officer. Doesn't even require an assault, and here you were physically aggressive with them, threatening with them. So the charge itself is not that complicated. The facts of you are what makes this much more complicated. I mean, the police are called to respond to some behavior that was at least partly driven by mental health concerns. But the prosecutor is exactly right. I mean, if you were following your treatment regimen and were sober and nonetheless had some mental break, I think courts would bend over backwards to try to find a way to work with that and to solve that problem. But the prosecutor is absolutely right. You decided to stop taking your medicine. You decided to also get drunk. You're responsible for that behavior. You've got a prior R&O on your record. You've been on probation in the past, and you haven't done well with that. You have a charge for drunk driving in the state of Indiana that you fled from 7 years ago, and they have a statewide pickup outstanding warrant. And for 7 years, you've just been thumbing your nose at the court in Indiana. So you're aggressive and threatening to the police. You don't do well on probation in the past. You're thumbing your nose at a court system as we stand here today.
The judge is wrestling here, and you can feel it. On one hand, Mr. Latrell shows effort. He's engaged, back on treatment, has support letters. But on the other hand, 7 years of evading justice and prior probation failures loom large. This isn't just about today's behavior, it's a pattern. The courtroom is weighing mercy versus accountability. And it's tense because the law doesn't ignore history. I want you to think, should rehabilitation outweigh a history of avoidance? Or should prior choices strictly dictate consequences? Drop your opinion in the comments. This is a case that sparks debate for a reason.
And then you come here and you want us to help you. But what makes it tough is it's very tempting to do so. I mean, I've got some good letters from your employer. This was a couple years ago. You've gotten back on your treatment, and you're engaged, you're working. I'm hesitant to kind of upset the apple cart with those things. I really am. But man, it's just really, really tough to go out of my way here for somebody who's going out of his way to avoid justice. You've been going out of your way for 7 years to avoid justice for a serious charge, driving under the influence with a high BAC. The people of Indiana have the right to have justice on that charge. I don't know if you're guilty of it or not, but they've got the right to have that charge go forward. And you're an absconder from justice on that charge. So I don't know. I don't think putting you on probation is a great idea. So there's fines and costs of $130, crime victims assessment, $68, state costs, $350, and court costs, and I'm going to order you serve 6 months incarceration in the Presque County Jail with credit for 4 days previously served. That is a sentence within the advisory.
So here's the final breakdown. Mr. Latrell faces 6 months in the Presque County Jail, fines, and costs within advisory guidelines, reflecting both his recent behavior and a history of avoiding justice. The judge balanced mental health considerations with the need for accountability, and the sentence lands squarely in the middle of the guidelines, neither overly harsh nor lenient. This case underscores the critical intersection of mental health, substance use, and legal responsibility. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.